my question to you, by the rule of hands, who has ever assembled IKEA furniture? Okay, cool. Now that's our story. That's 66 words definition of the AI system in the EU AI Act. Typically, you don't have one-pager instruction how to assemble IKEA furniture, but you don't go to the extreme as well. But maybe EU Commission decided to take the inspiration from the IKEA and to define the 66 words in the regulation itself. They decided to land to this Frankenstein, 32,667 words to define what is AI system. That's a guidance on the particular definition of what AI system is. Now the question to you is, with all of this complexity, do you really want to wait till 2nd August 2027? Me personally, I wouldn't wait, but up to you. So today I will try to debunk some of the myths that I heard within the last 2 years from the legal manufacturers, from some folks from Senelec, some folks from ISO, and how it lends to the conformity assessment. My name is Zaretsky. I'm Associate Head of the AI Notified Body in BSI. We can speak with you the full day about the nuances of all the 113 articles and 13 annexes. And probably we will find new answers in the definitions, how it links to the specific annexes or articles, but you don't need to have another one lecture from ML engineer how to go through the regulation. So I would focus instead with you today on a conformity assessment, and specifically that what you'd like to hear from the notified body, what exactly it would look like. Please take into account that for the MDR and IVDR, we do have the competent authority in the Netherlands, that would be IGJ, but not for other type of the high-risk AI system covered by the EU AI Act. For today, we will go through 3 main topics. First of all, we will go to debunk some of the myths that as a notified body representative I heard last 2 years. Then I will show you what would be the 3 pillars of the conformity assessment as a part of the EU AI Act. And then I would give you the key messages that I would love you to take with you back home. All right. Destination number 1, myth busters. So, myth number 1, the rule of thumbs again. Thumbs up if you think that it's true, thumbs down if you think that it's false. So, myth number 1, if my device automates a clinical or operational process, it's automatically an AI system and falls under the EU AI Act. Thumbs up, thumbs down. Most of you went with thumbs down. Perfect. That's myth busted. This is actually a critical error because automation is not the same as AI under the EU AI Act. Probably your marketing folks from your companies would say, we do everything with AI unless we cannot sell the medical device, 2025, right? But legally and machine learning specific terminology is not interchangeable. Automation doesn't mean AI by default. And my personal advice, before you jump to start any project, let's go do the gap assessment of what we have now with the EU AI Act, check the definition and see, is your device actually an AI under the EU AI Act? Don't waste your time. All right. Second, AI Act replaces the MDR for AI-specific requirements. Thumbs up, thumbs down. Thumbs down. Perfect. That's what I'd like to hear from you. Okay, that's busted. As Eric has mentioned already many times, AI Act is a horizontal legislation, MDR is vertical. So, in a legal principle, lex specialis derogat legge generale. Apologies for Latin-speaking people. So, which means that the vertical legislation actually wins over the horizontal one. Why I'm speaking about this? In terms of the conformity assessment, the medical device regulation for your devices, which would be the vertical, wins over AI Act, but it doesn't mean that you forget about one or another. They work together. All right. Myth number 3. AI Act requirements on predefined changes only apply to AI system based on reinforcement learning. Static locked algorithm is fine, no need. Thumbs up, thumbs down. Thumbs down, thumbs down. Okay, I've seen the right choices. Well done. Yes, actually, myth is busted. There is a very dangerous myth about the reinforcement learning that, and only for this one, the predefined list of changes would apply. No, actually, the law applied to all type of the system which falls under the definition of the AI system under the EU AI Act. No matter is it the algorithm which learns based upon the operational data that you feed into on a daily basis, or the model itself which has been trained on a data and validated on the data and which doesn't learn in a production environment on the data that you feed into. All right. Myth number 4. My notified body can now demand access to my data, training, validation, testing, and even my trained models. Okay, confirmed, confirmed, confirmed. Okay, cool, yes. You're right, well done. Sounds alarming and sounds like a science fiction, but actually it's true. Under Annex 7, your AI notified body can request an access to the data on which your model has been trained, validated, and tested, including, by the way, operational data on which it's running. And it's another topic for the long conversation, how your notified body as the third party can access the data in the operational environment, for example, from GDPR perspective. But again, not for now, but your notified body can access both model with a full parameter, including hyperparameter fine-tuning. All right. Last but not least myth that I heard, the requirement for automatically generated logs is just a formality. True, false, thumbs up, thumbs down. Okay, well done, busted. Actually, under Article 21 and Paragraph 2, not the notified body, but the competent authority for the AI Act specifically, not a vertical but horizontal. We don't have yet defined competent authority. Welcome to the club of people who are waiting for them. There are some, of course, probability what authority would be, but not officially yet. But they can access AI system generated logs. Would they have a capacity to assess them? Questionable, but they do have legal rights to request the access. All right, now our destination number 2 in our journey, the conformity assessment and 3 pillars. You probably would ask me, why the hell on earth this guy is speaking about 3 pillars of the conformity assessment? We were always done 2, QMS and technical documentation. Please bear with me. All right, so under the EU AI Act, we have, as you usually have in the medical devices, QMS assessment. QMS audits would answer the question how your processes are organized to make sure that your technical documentation as an output of the work of all your processes in QMS well prepared and structured in accordance with the EU AI Act requirements, as well, because we're speaking about the vertical legislation, your Annex 2, Annex 3 of the MDR. So, but then we do have the new guest in-house testing. Why are we speaking about the testing? So if your sectorial legislation notified body during the conformity assessment would not be satisfied with your answers on their questions on your technical documentation, and they would not be fully satisfied with results of the training, testing, and validation of your model, which led to the AI system before going into the production, the notified body can challenge you and say, we'd like to have access to your data and would like to test the data sets on which the system has been trained and validated, and would like to have an access to the model with the full parameters, weights, and so on and so forth, full architecture of the model. All right, so now let's assume we're in somewhere 2026, your early birds who like to be not in a reactive mode, but in a proactive mode. You prepared everything and you're like, perfect, I'm ready to go to my notified body and run the conformity assessment after, let's say, 2nd of August 2026, and you'd like to say, okay, I do have 1 year, I know that I'm slow, the notified body would be slow as well. Okay, 1 year would be enough. All right, you're ready. Then what the next step? The QMS audit. And on a QMS audit, I do have the super bonus for you. Myth number 6. Either 42001 will be harmonized and used as a part of the conformity assessment for QMS purposes. Thumbs up, thumbs down. Okay, it's actually not true. So as it has been stated many times by the EU Commission, ISO 42011, as well as, by the way, 23984, which is risk management standard in ISO domain, they will not be used as the presumption of conformity under the EU AI Act, because the both of the standard, AI management system 42011 and the risk management 23984, both of them are not focused on product-specific requirements. So, all right, we've spoken already many times the abbreviation QMS. What does it mean in a plain English? Quality Management System. All right, it doesn't help you at all. Then we will tackle down the AI Act. No definition of QMS. On a European level, you would go, for example, to Eurostat. And Eurostat, for instance, give you a definition of the quality management as the application of formalized system that documents the structure, responsibilities, procedures, blah, 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 blah. It doesn't give you any particular insights what to do with this Frankenstein. All right. Then, in a new legislative framework, and MDR, IVDR, and many other regulations now the part of this new legislative framework, AI Act as well, new kid on the block, but still the part of the new legislative framework. Standard ISO 9000 was used to keep the definitions. Okay, and to keep the long story short, you do have the definition of the quality management system in 3.5.4. Then to define some terms in this, you need to go to 3.5.3. And basically, it opens for you this nasty Russian doll when you need to define one principle and you need to open it, open, and open again. And to simplify the life, I saved you maybe half an hour. I run through all of these definitions and connect them into something that we can work with. Now we do have the definition of the quality management system. What we're going to do with this? Let's land back on the reality of the EU AI Act. EU AI Act would speak about Article 17, specifically to the quality management systems. And that's actually your aha moment. Why all of this aha moment here? Because Article 17, at the end of the first sentence, would stay with this regulation. What does it mean? That the Article 17, it's not just your checklist, which would say, okay, go through all the requirements of the Article 17, you're compliant, well done, your notified body will be happy, you can ship the product to the market. No, not yet. The true story here happens because the last part of the phrase anchor you to the whole regulation. And voila, we do have here the set of the interconnected requirements from the Article 17 to the whole regulation where it speaks about the requirements which can be interpreted into the quality management system, which means the process. Whatever deals with the process to be implemented, you have here and several others because it's not so huge slide, otherwise you cannot see. And why am I speaking about this? Because Article 17 does not speak, for example, about the non-conforming product, but Article 82 speaks about that in case you have the non-conforming AI system on the market, you should be able to withdraw it, put some changes, etc., etc. So, which means that you need to connect Article 17 to Article 82, for example. And on this slide, I will show you just a high-level list of the examples. Basically, not to go into the details here, in a message, I will send you the full list of the intermaps. So, okay, why I was speaking about all of this? Regulation itself answered the question, what? The harmonized standards, as Eric has mentioned before, answer the question, how? So, now the challenge, EU Commission, by the history with MDR and IVDR, they know already that, okay, the harmonized standards, still not yet with MDR, not the full package of them. So they decided to be proactive. So, and they issued the request for standardization request. So what does it mean? Our guy, the QMS standard, is there, including the post-market monitoring. And you have heard already from Eric what are the implications of the cross-link between the post-market surveillance and monitoring. All right, I would not put the details there, but the good part is that the work in progress about the EN AI QMS standard, which will be harmonized. Your humble servant is working on this, but frankly speaking, between us, to find the consensus with a bunch of experts from different sides of the coin, not always easy. So you heard already a lot of the promises that August 2025, we would have the harmonized standards. We know where we are. And my personal prediction, not official opinion, that we will not have it until somewhere next August. So, but again, my personal prediction. So, you heard from Eric about the horizontal challenge. Why do we speak about this? Two conditions that your system falls under the high-risk definition of the EU AI Act. It's product itself as AI or safety component, and it should go through the third-party conformity assessment. Right, okay. Or it should be covered in Annex 3 of the EU AI Act. So, personally, my team, we are working on Annex 3, where we would focus on the biometric type of systems, but AI notified body in BSI environment, our competences, technical skill set, QMS auditors, etc., would support the medical device notified body. So we're working like if you call, two sisters. Why I was speaking again about all of this horizontal? Because you have already the QMS. It doesn't mean that you need to start from scratch only to comply with the EU AI Act. So do the math. Highly likely what you would do, what I would do if I would be you, I would inject the requirements from the EU AI Act to your existing environment and say, okay, I've implemented everything, I've done my gap assessment, now I see that it's all running. I don't need to recreate the wheel and do another quality management system just for the sake of showing this to auditors. So, and that's exactly how you would likely to illustrate this. That's your existing one, your compliance checklist, and you try to fetch it actually from the new standard to your existing QMS. But mind the gap, because first of all, regarding the post-market monitoring activities, regarding the risk management, the MDR focuses on product safety and product performance. On top of this, AI Act adds the third dimension, is the fundamental rights. So on all of what you have already, you need always to keep in mind the fundamental rights. I'm not ethicist, so that's not my personal topic of choice, but you need to keep it in mind. So AI lifecycle management, in medical devices you do have 63 or 4 for the medical device software, but it doesn't cover AI system lifecycle. For these purposes, you can keep in mind the standards like ISO 5338 until it's harmonized, or maybe it will be another one, a reinvention of the wheel by the EU, and we would have something else. The data lifecycle management, not only the process itself, how do you collect the data, aggregate the data, clean, brush, and prepare it to train on this your system, but also data quality aspects. System logging, we've spoke about it earlier, human oversight, additional requirements, literacy. Eric has mentioned already about this. So, from practical steps perspective, your notified body highly likely will do the delta assessment. What you do have already, what are the requirements of the Article 17 and associated articles, unless we do have the harmonized standard. And my prediction is that your notified body, I cannot speak about all of them, I can speak what BSI will do. We will go through the gap assessment, what exactly you do have, what you don't have, and we focus on what we have, what we didn't assess yet before, and we would focus on this. All right, so now part of the journey is completed. Now technical documentation assessment. So typically you do have this type of Bible, and your technical auditor would run through this documentation, would go through the round of questions. I personally would try to urge the topic that we're trying to shift, all the notified bodies will try to shift from the bunch of the PDF files to the data to data. So you can plug in your data to the infrastructure of your notified body, not for this round. As one of the topics here, your notified body can challenge you and go with the testing. And we will speak about this a couple of minutes later. So what are the areas of interest of your notified body in the technical documentation? So most of them are here, but basically what your notified body will focus on the areas which have not been covered before formally. So AI and data lifecycle. I know that companies like BSI and many other our colleagues who already assessing AI as a medical device, we're not formally assessing them against the EU AI Act, but of course the standards are already published in ISO domain, so which means that following the GDPR requirements, we covering some of these topics already, but not all of them, again. So first area of interest, and it's just an examples, AI description. That's where high-level questions we would like to cover. The second area would be the data sets. So it's the bread and butter for your AI model and for us as well. And the third one, of course, it's training and testing related to your, not just the final AI system, but the model behind it. All right? Now, next and final step, I mark it as a green tick, but they should be somewhere together because the technical documentation and testing go hand by hand. How does it look like? And I cannot speak on behalf of the all notified bodies, but how it's organized at BSI. You do have your model, your data set, you or upload all of this to our cloud or connect us to your cloud. We run the testing and we run through the metrics. The metrics would depend on what type of the AI system are we dealing with and what kind of standards we have already harmonized. If some of them are not harmonized, then we would tell you, okay, we need to run your system against this type of metrics because X, Y, Z. Then we would have the automated report because the test is run automatically. Basically, then we would assess the results from the system against the specific industry benchmarks. And this type of standards we're using in automated way to run your data and your model through the metrics from these standards. And here it's not the full list of standards. All right, so let's assume that we successfully completed your journey. And what type of key messages I'd like to take home with you. So first, check the definition, check the scope, and check the original source of data, EU AI Act, before you jump into the conclusion and start any project and invest, I don't know, X amount of money for be compliant with the EU AI Act. Second, they apply both to you if the point number one is successful and you see that AI system is actually AI system under the EU AI Act. Third one, be ready that the paperwork will not be there anymore because of the amount of the work that your notified body will need to do. And we will have more closer and warmer relationship with the company because we can run the tests and we would see the data, we would see your model, etc. We will be a little bit closer and the speed need to be faster. So don't still rely on the bunch of paperwork. 3 legs of the conformity assessment, QMS, technical and testing, keep it in mind. 3 domains. And the last but not least, don't wait 2027, it's already here. So thank you so much for being with us. And remember, it's the journey, not a destination. Thanks a lot.